everybody. I'm John Giardinelli. I'm Association Counsel, and this is John's Rants. I've talked to your professional standards administrator, and she indicates that we've been getting a lot of questions and calls about some listing issues and some other MLS related issues. So I thought it might be a good idea to revisit a couple of those items, and then if we have time, I want to go over a couple of things that are going on with the Department of Real Estate on a statewide basis. So, real quickly on listings. Bottom line, you got to have an agreement. You cannot put a listing in the MLS without a written agreement. Now, I've been told, I don't use the hotline obviously, but I've been told that, and CAR sometimes will say something like, well, if you have one signature, then you're okay to list, but you're going to obviously have to have everybody's signature and to sell. That's not necessarily true. Um, it is conceivable that let's say, for example, I have a property and I own it with a couple of other people. We can give the authority to one person to go ahead and handle the listing and all of that, but there has to be something giving that authority. Otherwise, all required people need to sign the listing agreement. So don't just assume that you've got the authority to list the property for sale. You need to make sure that you've got all necessary signatures. And if you're not sure, you want to make sure that any other sellers have consented. Otherwise, you're going to get to a point where an offer is going to come in, and if some people decide to balk at the offer, you're going to be in some serious trouble. So remember that the document needs to be signed by all necessary parties, or there needs to be something authorizing the one person. If you don't have that, then you're susceptible to not only some legal issues, but a fine. You could be susceptible to a claim that you were falsely advertising the property. The Code of Ethics, both Articles 1, 3, 3 is the article that says you have to cooperate. Well, if you're marketing a property and I respond and I cannot, I make an offer and then it turns out we can't get that offer done because other sellers haven't properly signed or authorized, then you could be in violation of the article that says you have a duty to cooperate with everybody. You also could be in violation of Article 9 that says that all agreements must be in writing. Article 11, which says you're acting incompetently, and Article 12, which goes along with the MLS and the DRE rules, which says you could be guilty of false advertising. So be very, very careful about taking a listing and not getting all of the signatures that you need. Now, if you are representing the buyer, you cannot show a property. That means you cannot enter a property either virtually or physically with a client without a written buyer representation agreement. You must have that agreement. That is what the settlement that settled all those class actions last year said, that before you tour, quote unquote, a property, you must have a written agreement. Now, that is different than state law. State law says that you must get a written agreement as soon as practicable, but if your client won't sign an agreement, and you can prove that by documenting your file properly, that your client won't sign a written agreement, then that is not a violation of the state law, but you still cannot show MLS listed properties by or risk a very substantial fine. So understand that the state law is a little bit different. What I would suggest you do is, if your buyer doesn't want to sign a 5-page BRBC agreement for a long period of time because they've just met you, maybe they're not really clear, they just want you to show them this one particular property, use the PSRA form where you can do it for one day. you could do it for one property, and everything expires at the end of that day, unless an offer is made. And if that's the case, then it satisfies all of the requirements of both the law and the MLS rules, and you're perfectly okay to do that. Again, also remember that you cannot enter a property except as how the listing agent has directed. For example, if it's a lockbox, you have to follow those rules. If it's by appointment only, then that's what you have to do. You can only enter a property in accordance with what the seller has instructed the listing agent, and what the listing agent has put into the multiple listing service. A reminder that if you have a BRBC for a certain amount or a certain percentage, that's all you're going to get. Even if later on you find out that the seller is going to be willing to pay more. Now, a couple of other really quick rules that I just want to remind you about because they come up all the time. Number one, you must submit any valid listing within 2 business days under most of the rules. Number two, you are responsible for the accuracy of the information that you put in the listing agreement and in the listing itself. All of the information, regardless of whether it's linked or whether it's actually put into the agent remarks or some other place, needs to be clearly laid out and accurate. I have a right to rely on it. You cannot use someone else's photographs without permission of the photographer. And you must have a photo with the submissions that you're going to post. Remember that there is a coming soon status. That means you cannot market the property, and it's good for 21 days. It simply is, it's kind of like, I don't know how you would describe the previews at the movies, right? You can't see the movie yet, but I'm just telling you, hey, this is what's coming in a couple of weeks, and all of that kind of stuff. Again, there's also a hold. If for some reason your seller doesn't want to move forward at the present time, but you don't want to cancel, you can always put the property on hold for a short period of time. And of course, you have expired statuses as well. Again, you cannot advertise someone else's listing without that participant's permission, and that permission is set forth how you get that in the rules. What happens if, gosh, I'm trying to get a hold of the listing agent. They won't cooperate. They won't return my phone calls. The rule says that you got to make a good faith effort to contact the agent and maybe even the broker. But if for some reason you cannot reach either of them and they won't return your calls, they won't respond to your texts, whatever it is, you can contact the seller, but you have to make an effort to contact the seller through the broker for at least 24 hours, at least 24 hours. And you better be able to document it. And then there's some exceptions to those rules. So if you're in a situation, pardon me, where you're not getting cooperation, then it's incumbent upon you to work with the broker, but you can contact the seller directly under those limited circumstances. Check the rules. They're pretty clear and pretty straightforward. So you may want to do that. Again, if the seller wants to exclude a property from the MLS, there are procedures to follow. I talked to the Department of Real Estate about that, and they've made it very clear that whether it's a private listing network or whether it's simply an exclusion, that you better be able to establish that this was the seller's decision and not something you did so that you can try and double end the deal. because again, they don't care about the listing issues. They're not really worried about multiple listing service rules, but they are concerned about protecting the consumer. And if you breach your fiduciary duty to the consumer, then you could end up in some pretty hot water. So be very, very careful about that as well. Remember that CRMLS has a very extensive and very straightforward citation policy, that if you get more than 3 citations in a year, it will come to the association as an ethical violation. And if you want to appeal those appeals, there are very specific rules for how you appeal a violation. And if you are wanting to appeal, think about it, talk to your lawyer, because there's some definite benefits to not appealing. But if you're going to appeal, there's different ways you can appeal, and there's some very real benefits to appealing in certain ways as opposed to others. For example, if you were to appeal uh, and have just a paper review, then there are going to be no additional penalties for you, no other fines. But if you decide, hey, I want a full-blown hearing, I want it to go to grievance, I want a full-blown trial, then remember that the panel is not going to be limited in how much they can fine you. And if they decide that you're acting in bad faith or for the purpose of waiting too long, you could end up in some hot water with a much larger fine. So be very, very cautious about that. All right, well, that's kind of, I just wanted to give you a little taste of what we've been getting, and maybe clear up some things. Obviously, there's no substitute for getting a hold of CRMLS. Their rules are posted. They have all kinds of resource material. They have marketing advisories. They have advertising advisories. So if you're not clear, call them. The attorney that heads up compliance is a guy I've known for a number of years. His name is Jeff Smetana. Jeff's an excellent lawyer and a good guy. And so him and his staff will be more than happy to make sure that you're clear on what you should be doing. The bottom line is they're very proud of the fact that most of the things that come to them as violations are resolved without fines, without any form of penalty. So take advantage of that corporate culture and get your questions answered ahead of time rather than waiting for a fine. It just doesn't make any sense, frankly. And always remember, at the forefront of everything is that you have duties to your client, and those duties are first and foremost. A couple of real quick things from the Department of Real Estate. The regulations dealing with the mandatory uh, 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 requirements that you have a written agreement with buyers will be coming out right around January the 1st. These regulations deal with the amount of time, with open houses, all kinds of stuff. I'll go into a little more detail the closer we get when I know the rules are final. Probably do it in a rant next month. But what I want you to understand is that these regulations were written and they are not antagonistic towards organized real estate. In talking to the commissioner's office and their attorneys, you can expect that in 2026, you're going to see some regulations relating to artificial intelligence. There are some areas where the legal office of the DRE is concerned with the way that data is being gathered up, privacy issues, fiduciary duty issues, accuracy of information, things like that. So you can fully expect that there will be some detailed regulations coming down next year, along with some regulations dealing with broker supervision. One that I'm comfortable will come out sometime next year is a regulation that will require, as part of their duties to supervise, that brokers provide mandatory training. It's not a correct statement that because you're independent contractors, you don't have to attend classes. If a broker has to supervise you, they're going to be able to require you to take classes. And if you don't, there could be some negatives for that. There's a new law that I'm not going to go into today. It'll be part of something we'll be covering in one of our newsletters, but it's a law that basically will say you're going to be required, if you modify in any way a digital photograph that's going to go to the multiple listing service or is going to be part of your advertising, that you make certain disclosures. And again, we'll go into greater detail. The law does go into effect on January the 1st. And as far as all these escrow disbursement issues, we're getting very close to a resolution. Nothing's final, so I really am hesitant to tell you what it looks like, but I can say pretty much that the rules that apply to the public escrow companies and the rules that apply to the broker-owned escrow companies are going to be very, very similar, if not identical, and that it's going to be something that makes a lot of sense, I think, for all licensees.